Welcome to our comprehensive guide on competition law in India. In this video, we'll explore the core principles, objectives, and regulatory framework that shape the Indian market. The Competition Act 2002 was enacted to foster fair competition, prevent anti-competitive practices, and protect consumer interests. We'll break down key concepts, landmark cases, and practical examples to help you understand how competition law impacts businesses, consumers, and the economy. Let's begin by setting the stage for why competition law matters and how it influences market dynamics. Competition Act 2002 aims to promote a fair and healthy competitive environment. Its primary objectives include preventing practices that have an appreciable adverse effect on competition, protecting consumer interests, and ensuring freedom of trade. By regulating agreements, abuse of dominance, and combinations, the Act strives to create a level playing field for enterprises. This ensures that markets remain dynamic, innovative, and responsive to consumer needs. Understanding these objectives is crucial for grasping the broader impact of competition law on the Indian economy. Anti-competitive agreements are central to the Competition Act's enforcement. Section 3(1) prohibits agreements related to production, supply, distribution, storage, acquisition, or control of goods and services that cause or are likely to cause an appreciable adverse effect on competition (AAC) in India. Even agreements made outside India can be scrutinized if they impact the Indian market. Section 3(2) declares such agreements void, reinforcing the Act's commitment to maintaining market integrity. These provisions ensure that businesses operate fairly and do not engage in practices that harm competition. Anti-competitive agreements are categorized into horizontal and vertical agreements. Horizontal agreements occur between enterprises at the same production stage, often rivals, while vertical agreements involve enterprises at different stages of production or distribution. Each type has unique implications for market competition. Understanding these distinctions helps in identifying and addressing anti-competitive practices effectively. The Act provides specific rules and presumptions for each category, ensuring targeted enforcement and clarity in legal proceedings. Horizontal agreements are made between enterprises or persons engaged in identical or similar trade of goods or services. These agreements are presumed to be anti-competitive under the per se rule, meaning they are automatically considered harmful to competition. Examples include agreements between manufacturers of the same product or service providers offering similar services. The Act identifies specific types of horizontal agreements such as cartels, price fixing, limiting production, market sharing, and bid rigging, all of which are presumed void due to their adverse effects. Cartels are a serious form of horizontal anti-competitive agreement. Defined in Section 2(c), a cartel is an association of producers, sellers, distributors, traders, or service providers who, by agreement, limit, control, or attempt to control production, distribution, sale, price, or trade of goods or services. Cartel agreements typically involve price fixing, limiting supply, market sharing, or bid rigging. These practices distort market competition, reduce consumer choices, and often lead to higher prices. The Act treats cartels as inherently void due to their damaging effects. Price-fixing agreements directly or indirectly determine purchase or sale prices, either by maintaining actual prices or offering identical discounts in credit terms. Such agreements eliminate competition and are declared void under the Competition Act. Price-fixing can be explicit or implicit, but both forms undermine market fairness and consumer welfare. The Act's strict stance on price-fixing ensures that businesses cannot collude to manipulate prices, thereby protecting the interests of consumers and maintaining healthy competition. Agreements that limit or control production, supply, markets, technical development, investment, or provision of services are considered anti-competitive. These arrangements restrict market growth, reduce consumer choices, and can lead to monopolistic practices. By curbing production or supply, enterprises can artificially inflate prices and hinder innovation. The Competition Act voids such agreements to ensure that markets remain open, competitive, and beneficial for consumers and businesses alike. Market sharing agreements involve competitors dividing the market among themselves, whether geographically, by product, customer, or other criteria. Each competitor agrees to operate only within their allotted segment, avoiding competition with others. This creates monopolies in specific areas, reduces consumer options, and often results in higher prices. The Competition Act presumes such agreements to be void, as they undermine the fundamental principles of free and fair competition. Bid rigging or collusive bidding occurs when competitors agree to manipulate the bidding process, often taking turns to win tenders by not competing against each other. This practice eliminates genuine competition, distorts market prices, and can lead to unfair allocation of contracts. The Competition Act treats bid rigging as a serious anti-competitive offense, presuming such agreements to be void. Landmark cases have clarified that mere price parallelism is not enough to prove bid rigging. Coordinated behavior must be demonstrated. Vertical agreements are made between enterprises at different levels of the production or distribution chain, such as between suppliers and manufacturers or dealers. Unlike horizontal agreements, vertical agreements are not presumed anti-competitive. Their legality is assessed using the rule of reason, which weighs pro-competitive benefits against anti-competitive effects. Only those vertical agreements causing or likely to cause AAC are declared void. This nuanced approach allows for flexibility in evaluating the impact of vertical arrangements. Rule of reason is a legal approach used to assess vertical agreements. Courts evaluate the specific facts of each case, considering the business context, market conditions, and the nature of the restraint. The goal is to determine whether the agreement regulates and promotes competition or restricts it. Only agreements with appreciable adverse effects are prohibited. This principle, established in landmark cases, ensures that not all vertical arrangements are treated as anti-competitive, allowing for a balanced and fair assessment. Buy-in arrangements require purchasers to buy a secondary product as a condition for purchasing a desired product. For example, a seller may tie a popular item with another less desirable one, forcing buyers to purchase both. The Competition Act scrutinizes such arrangements, especially when the seller has significant market power. Key criteria include the presence of two distinct products, sufficient market power, and impact on a substantial amount of commerce. These arrangements can restrict consumer choice and competition. Exclusive supply agreements restrict purchasers from acquiring goods from other sellers. This means a supplier may prohibit dealers from sourcing similar products elsewhere. Such agreements can create entry barriers, limit competition, and foster monopolistic practices. The Competition Act evaluates these arrangements under the rule of reason, considering their impact on market competition and consumer welfare. Only those causing appreciable adverse effects are declared void. Exclusive distribution agreements limit or allocate the supply of goods to specific areas or markets. Sellers may restrict dealers to certain regions, withholding output from others. These arrangements can reduce competition, create monopolies, and impact consumer access. The Competition Act assesses such agreements for their actual or potential adverse effects, ensuring that distribution practices do not unfairly restrict market dynamics or consumer choices. Refusal to deal agreements restrict the persons or classes of persons to whom goods are sold or from whom goods are bought. For instance, manufacturers may require dealers to source products only from authorized vendors, excluding independent suppliers. Such practices can create monopolies, foreclose competition, and lead to exploitative pricing. The Competition Act evaluates these agreements for their impact on market access and competition, declaring them void if they cause appreciable adverse effects. Resale price maintenance involves agreements where sellers stipulate the prices at which goods can be resold by purchasers. Dealers may be required to adhere to maximum permissible discounts or price ranges set by the manufacturer. Such practices can limit price competition and harm consumer interests. The Competition Act scrutinizes these arrangements, penalizing those that restrict dealers' ability to offer competitive prices and thereby reduce market competition. Section 3(5) of the Competition Act provides exemptions for agreements protecting intellectual property rights, IPRs, such as copyright, patent, trademark, and designs. Reasonable conditions imposed to safeguard IPRs are not considered anti-competitive. However, registration alone does not guarantee exemption. The conditions must be necessary and reasonable for protecting rights. The Act also allows export agreements to be exempt if they relate exclusively to production, supply, or distribution for export purposes. Abuse of dominance occurs when an enterprise imposes unfair or discriminatory conditions or prices, restricts production or technical development, denies market access, or leverages dominance in one market to another. Section 4(2) of the Act outlines these behaviors, emphasizing that dominance must first be established. Landmark cases such as Uber India and National Stock Exchange illustrate how predatory pricing and other abuses are identified and penalized. The Act aims to prevent enterprises from exploiting their market power to harm competition and consumers. Recent jurisprudence reflects a shift from form-based to effects-based analysis in abuse of dominance cases. The Competition Commission of India, CCI, increasingly requires proof of anti-competitive effects, such as harm to consumers or competitive disadvantage in the downstream market. Cases like Scott Glass and Tata Power Delhi Distribution highlight the importance of demonstrating actual market impact. This approach ensures that enforcement is grounded in real-world outcomes rather than rigid legal forms. Section 4 covers both exploitative and exclusionary practices. Exploitative abuses involve excessive pricing and unfair contract terms, while exclusionary practices restrict market access or foreclose competition. The CCI has addressed both types in cases like HT Media and Auto Parts, applying doctrines such as essential facilities and excessive pricing. These cases demonstrate how dominant firms can harm both competitors and consumers, reinforcing the need for vigilant enforcement. Predatory pricing is assessed using a two-step test. Prices must be below cost, and the enterprise must intend to reduce competition or eliminate competitors. The CCI uses average variable cost as a benchmark, but may consider other measures depending on industry specifics. Landmark cases such as National Stock Exchange and Ola Cabs illustrate how predatory pricing is evaluated and the importance of market dominance in determining abuse. This ensures that price reductions are not unfairly penalized unless they harm competition. Price discrimination involves treating equivalent transactions differently, resulting in competitive disadvantage among buyers. The Act prohibits both price and non-price discrimination. Cases like Scott Glass, Intel, and Microsoft clarify that differences in pricing are only discriminatory if they impede competition. Bulk discounts in different license types are not considered discriminatory unless they foreclose market access or harm downstream customers. The CCI's nuanced approach ensures fair pricing practices. Determining the relevant market is essential in abuse of dominance cases. The relevant market is defined by product and geography, identifying the scope within which dominance is assessed. Factors such as physical characteristics, price, consumer preference, and regulatory barriers help delineate the market. Landmark cases like Otto's Worldline and BCCI illustrate how demand and supply perspectives are used to define relevant product and geographic markets, ensuring accurate assessment of dominance. Dominant positions can be exploitative or exclusionary. Exploitative dominance involves excessive pricing or unfair contract terms, while exclusionary dominance restricts market entry or access. Cases like Pankaj Agarwal v. DLF and Sri Shamsher Kataria v. Sale Honda demonstrate how dominant enterprises can abuse their power, either by exploiting consumers or foreclosing competition. The Competition Act addresses both types, ensuring comprehensive protection against market abuse. Combinations refer to mergers, acquisitions, or amalgamations that exceed financial thresholds set by Section 5 of the Competition Act. The Act regulates combinations to prevent concentration of wealth and ensure healthy competition. Large-scale mergers and acquisitions are scrutinized for their impact on market dynamics, consumer welfare, and economic policy. The goal is to prevent dominant enterprises from taking over smaller ones and distorting competition. Combinations are categorized as horizontal, vertical, or conglomerate. Horizontal combinations involve competitors at the same production stage, often leading to monopolistic tendencies. Vertical combinations unite enterprises at different production levels, improving efficiency and competitiveness. Conglomerate combinations integrate businesses in unrelated markets, enhancing market share and synergy. Each type has distinct implications for competition and consumer welfare, requiring careful regulatory oversight. Section 5 sets financial thresholds for combinations, including asset value and turnover criteria. These thresholds ensure that only significant mergers and acquisitions are regulated. The Act distinguishes between acquisitions, group acquisitions, and mergers amalgamations, each with specific asset and turnover requirements. This framework prevents unchecked concentration of market power and aligns with India's economic policies. Competition Commission of India, CCI, is the regulatory authority responsible for enforcing competition law. Comprising a chairperson and 6 members, the CCI operates as a quasi-judicial body, offering opinions, advocacy, and enforcement. Its functions include eliminating anti-competitive practices, promoting consumer welfare, and ensuring fair trade. The CCI engages with stakeholders, maintains transparency, and fosters a competitive culture in the Indian economy. CCI follows a structured procedure for inquiries, starting with complaints or references from government or statutory authorities. Investigations are conducted by the Director General and reports are reviewed by the Commission. If contraventions are found, further inquiry is initiated. Appeals against CCI decisions are heard by the Competition Appellate Tribunal (COMPAT), which has powers similar to civil courts. This robust process ensures fairness, transparency, and effective enforcement of competition law.